Nous sommes le Subcommittee des...
We are the Human Rights Committee. We're on the 8th of March session. We have two witnesses today, James Doyle.
Center for International Justice, also Matthew Eisenbrand, who's the legal coordinator for the same organization. Colleagues, I would like to request your indulgence to deal with a matter in camera at the end of this meeting. This is part of the reason I'm in such a hurry. And that matter is a matter that we're all familiar with, but I can't do it unless we're in camera. Can I... First of all, do I have your permission? You all know what I'm referring to do that? Okay, good. Now, I see some hands. I saw Madame Deschamps, and I think I saw another hand, Professor Kotler. So, Madame Deschamps d'abord, et après, Monsieur Kotler.
If you will allow me, Mr. Speaker, Mr. Chairman, so often we come here at 1 o'clock, we're shoved around because one committee is ending and another beginning. I take the opportunity of pointing out that it's the 100th anniversary of International Women's Day. I wish to congratulate all the feminine staff in the House of Commons, our analysts, the employees of the House of Commons, employees in the various members' offices. I think it's worthy of being pointing out. So many women have worked to have our society progress.
We have the head table two analysts and a clerk, all of whom are female and very competent, and I'm also aided by my office manager, Sonia Wayand, who's extremely competent as well. I'm going to encourage everybody else not to comment on this subject, however, in the interest of time. Professor Kotler.
Okay, moi-même je voudrais associer, mais je ne vais pas partager des commentaires. I just wanted to ask you, Mr. Chairman, if we are able to take a few moments to address the motion which has been re-Iran that has been before you, last week as well.
Well, let's find out. If there isn't, if anybody wants to get into amending it, then I would prefer to push it aside till Thursday. But let's just confirm. Have people had a chance to look at it, and are people willing to pass it without amendment? If not, as I said, I prefer Thursday, given a time constraint. So very quickly, we're on the. Sorry, Mr.
At least on it, though.
Okay, all right. So can we leave this, Professor Kotler, till Thursday? Is that all right? Well, I was going to talk about that when we get to our camera. Okay. So, thank you very much to our witnesses. I'm not sure who wants to go first. All right, Ms. Stoyles, please lead away.
Membres distingués de la comité, je vous remercie beaucoup pour cette.
Distinguished members of the committee, I thank you for giving me the opportunity to discussing with you how we can ensure that the survivals of the most serious violations of the Human Rights Committee, such as torture, have the possibility of pursuing justice here in Canada when other possibilities have been exhausted.
On CCIJ's appearance before this committee in April 2009. With a number of CCIJ advisors and with Stéphane Kazemi and his lawyers to discuss the important issue of the need to amend Canada's State Immunity Act. As a reminder about my background, I'm the first executive director of the Canadian Centre for International Justice, which is based here in Ottawa and which I helped to establish. CCIJ is a charitable organization that works with survivors of torture, genocide, and other atrocities to seek redress and to bring perpetrators of these crimes to justice in criminal and civil courts, both in Canada and internationally. I am a lawyer, and I previously directed the global campaign to establish the International Criminal Court. Last summer, I was very honored to receive the Tarnopolsky Human Rights Award from the Canadian Bar Association and the International Commission of Jurists, which for me was a wonderful recognition of the increasing importance and the impact of the efforts that we and similar organizations in other countries are having as we seek to end impunity for international crimes such as torture and genocide. As you will recall, in April 2009, Stéphane Kazemi delivered a very eloquent statement to this committee about the importance of justice in response to the brutal torture and rape of his mother while she was on a work assignment in Iran in 2003. She died of her injuries after Stefan unsuccessfully tried to have her returned home to Canada for treatment. He was not even able to have her body returned so that he could give her a proper burial. Neither the government of Iran nor the individuals involved was ever held accountable in Iran. In fact, one of those responsible was promoted. And there's no possibility that there will be any justice in Iran. Stefan so poignantly talked about how difficult it is for others to imagine the harm caused by the loss of a mother and of her love, particularly under such horrific circumstances. But it's important that we do try to imagine what this would be like. As we all sit here in our professional capacities, we are also human beings with families, with mothers, with children, and despite what we may think, this could be our own story. Zahra Kazemi is not the only person to be tortured and killed in the notorious Evin prison and in other parts of Iran, not by far. Torture, crimes against humanity, and other atrocities are being perpetrated right now in many parts of the world against Canadians and people with a connection to Canada. We're all watching what's unfolding in the Middle East and the incredible violence and brutality being unleashed against innocent people who are simply seeking the most basic of rights, an end to dictatorship, a path to democracy, and the alleviation of extreme poverty. The fact that this continues today is in part, in fact, in large part, because it's still very rare for those responsible for these crimes to be held accountable in courts of law. We have the new International Criminal Court in The Hague, but it has limits on its jurisdiction and its funding, and it's premised on the idea that most of the cases for torture and war crimes will take place in national courts around the world. Canada's criminal courts have a very important role to play, yet it is very important that our civil courts in Canada also be in a position to play a role, as the federal budget allocates an insignificant level of resources to war crimes trials in Canada. Civil trials provide an alternative of allowing survivors and victims' families to go to court themselves. It's only with a large web of accountability mechanisms globally that we can send a strong and clear message to the likes of Iran's Mahmoud Ahmadinejad and Libya's Muammar Gaddafi that they cannot indiscriminately torture and kill to maintain their hold on power and their access to their country's resources and wealth. At our previous appearance before this committee, we discussed in detail how the opportunity for survivors of torture with a connection to Canada and the family members of victims, like Stefan Kazemi, are effectively barred from proceeding with their claims by Canada's State Immunity Act. The purpose of the Act is to allow foreign government officials to carry out their official duties without fear of lawsuits. Yet, as it currently reads, the State Immunity Act also protects the government and its officials from lawsuits even when they torture and kill a Canadian. While it contains some exceptions, it does not explicitly include an exception to the immunity protection for acts of torture and other serious international crimes. Since our appearance before the subcommittee in April 2009, we have seen two very important developments to remedy this problem. So we want to talk about these developments today and also to discuss what might be the next steps. The first development was the introduction of Bill C-483, the Redress for Victims of International Crimes Act, that would squarely address the problem. The second was a decision by the Quebec Superior Court on the issue of state immunity in the Kazemi case in late January of this year, a decision that makes the need for Parliament to act by passing Bill C-483 all the more clear. The CCIJ very much welcomed the introduction of Bill C-483 at first reading on November 29, 2009, and its reintroduction on May 3, 2010. The bill was introduced as a private member's bill by Liberal MP Irwin Cotler and have the support of Conservative MP Scott Reid, NDP MP Paul Dewar, and Bloc Québécois MP Francine Lalonde. This bill proposes to amend the State Immunity Act to prevent a foreign state from claiming immunity from the jurisdiction of Canadian courts in legal proceedings that relate to genocide, crimes against humanity, war crimes, or torture when domestic remedies have been exhausted. In other words, Stefan Kazemi, or a torture survivor, him or herself, could sue human rights abusers like the government of Iran and the individual torturers. You, as members of this subcommittee, clearly demonstrated in your report on the situation in Iran, issued at the end of December 2010, that you understand the importance of allowing civil cases to go forward in Canada against torturers and war criminals, and the barrier to justice that is currently created by Canada's State Immunity Act. CCIJ welcomed recommendation number 13 in the report that the Government of Canada remove immunity for foreign officials for gross violations of international human rights law from the State Immunity Act, and the recognition in the report that Bill C-483 would achieve this. The need to ensure such an amendment to the Act through the prompt passage of Bill C-483 has been made all the more clear by the ruling of the Quebec Superior Court at the end of January in the Kazemi case. The ruling was in response to the claims made by the government of Iran that neither the government as such nor any individual officials can be made to stand trial in Canada for torturing and murdering a Canadian because of the State Immunity Act. The ruling provides a very mixed result. It has some positive consequences for Stéphane Kazemi, but with such a narrow approach that it will be very unlikely to allow most other victims a right to a remedy in Canada. Stéphane's personal claim has been allowed to proceed, and this is, of course, extremely positive. As we noted previously, the State Immunity Act currently contains several exceptions. One of these is for harm suffered inside Canada, and it is because of the existence of this exception that Stéphane's claim can proceed. The Quebec Superior Court found that a claim may be brought by someone in Canada who suffers significant trauma as a result of the torture of a close relative in another country, as Stéphane did. This was a very important interpretation of this exception to the State Immunity Act, and one that, unless overturned on appeal, will result in the first Canadian civil trial for torture committed overseas. At the same time, the court found that there is no right to a remedy for a torture victim who dies overseas. The harm did not occur in Canada, so it does not give rise to an existing exception in the State Immunity Act. The court explicitly refused to read a new exception for torture into the Act. So Zara Kazemi's estate is barred from proceeding with its claims in this case because the harm that Zara herself suffered did not occur in Canada. One of the unfortunate outcomes of the ruling is that it could create an incentive for torturers to ensure that their victim dies. If Zara had survived and returned to Canada, she would likely have suffered significant psychological harm inside Canada as a result of her traumatic experience. She might then have been able to sue Iran, according to this Quebec court ruling, arguing that this harm falls within the exception to the State Immunity Act. The court was clearly indicating that it could use only the existing exceptions written into the State Immunity Act by Parliament. By refusing to go further so that the ruling could apply beyond Stéphane Kazemi's unique circumstances, the court was sending a clear invitation to Parliament to take up this issue. Bill C-483 does just that, and it is members of this committee who understand why it's important for governments like Iran to be sued for torture, and who are in the best position to update Canadian law to make this possible. Recognizing that this committee does not formally have Bill C-483 before you for consideration, we would like to ask that you do all you can to seek its passage in your individual capacities. First, we ask that you speak to your party leaders and their staff about the need for the bill. Second, we hope that you will think of who else within your parties would work closely with you to champion the bill and approach them to request that they assist you in building support, including going to the clerk to have their names added as seconders for the bill. And finally, we hope that you will do whatever you can to raise awareness of the issue and the need for the bill more generally within your parties. I would offer the suggestion of raising it during caucus meetings and regional caucus meetings. And we have an event this Thursday at 12 noon when Stéphane Kazemi will be with us again. That's taking place in the press building on Spark Street at 12 o'clock. And we hope you will invite your colleagues to this opportunity to hear more about this issue. Of course, you know much better than we do how to build general support within your party, and I'm sure you will have many other ideas. When Stéphane Kazemi appeared before this committee almost 2 years ago, he made the point that since his mother's death, he has been all consumed by the effort to seek justice. He has been crystal clear about the fact that in no way does he want to profit financially from her torture, and that the court case is about his need to see someone held responsible as part of his effort to rebuild his life. The Quebec court decision would allow that, but in speaking with the media, Stéphane has also eloquently articulated how deeply he had hoped and still hopes that he can make a difference for other people. His mother stood up for the rights of others through her work and paid the ultimate price for doing so. Now Stéphane wants her death to help ensure that other people, other Canadians, are not tortured, raped, beaten, and murdered. Bill C-483 would provide one very important tool to help Stéphane to realize that goal, and we hope that we can count on each of you to get it passed as quickly as possible, so that torturers and war criminals will no longer be able to fend off responsibility when they order and participate in such horrific acts of violence. I thank you very much for your time and your attention to this important issue. Je vous remercie beaucoup pour votre attention et assistance.
Thank you very much for your attention and your help. Thank you.
Eisenbrand, please.
Thank you. Distinguished members of this committee, I also want to express my sincere thanks for the leadership that you have shown on the need to ensure that there is access to Canadian civil courts to sue governments like Iran for their torture when there is no other justice option available. We very much appreciate this opportunity to be with you today to discuss how to achieve this. I'm the legal coordinator for the Canadian Centre for International Justice, and I've held this position for 3 years. Previous to this, I served for more than 5 years as the legal director of the Center for Justice and Accountability, a U.S.-based nonprofit organization that also works to prevent torture and other severe human rights abuses by helping survivors hold perpetrators accountable through legal cases. I have worked on CCIJ's intervention as a friend of the court in the Kazemi case to provide legal analysis about the issue of state immunity, and I coordinated a workshop of leading Canadian and international legal scholars and practitioners who came together at the University of Ottawa in 2008 to discuss what changes were needed in Canadian law to allow torture survivors in Canada to have access to justice. Having endorsed Bill C-483, we thought this committee would be interested in hearing some of the key arguments that weigh in favor of this legislative change and the responses that can be given to what we anticipate may be some of the questions or concerns raised by your colleagues as you discuss it with them. First, it is important to note that there's a global trend away from immunity in civil lawsuits. Most countries do not have legislation providing immunity to foreign governments, including almost all civil law countries, which make up 2/3 of the world. Many also allow victims to file civil claims in conjunction with criminal prosecutions of torturers and war criminals. Courts in the United States have heard dozens of lawsuits for torture and other atrocities, and the U.S. Supreme Court recently ruled that the United States immunity law, which is very similar to Canada's, does not grant immunity to individual officials. Italy's top court has ruled on several occasions that Germany is not immune in lawsuits for Nazi-era abuses. Even though the UK House of Lords did apply immunity in a torture case, that decision is now on appeal at the European Court of Human Rights. An important United Nations committee has underlined the trend away from immunity and pointed to Canada as being in violation of its international legal obligations in this regard. In 2005, the United Nations Committee Against Torture, the body charged with overseeing the proper implementation of the Convention Against Torture, made it clear that the Convention requires all states to provide civil remedies to survivors of torture. Canada and most other countries have ratified the Convention, and the committee pressed Canada to, quote, ensure the provision of compensation through its civil jurisdiction to all victims of torture, close quote. This was shortly after the Ontario Court of Appeal found that Canada's State Immunity Act barred a claim against Iran for the torture of an Iranian man who is now a citizen of Canada, Hussein Bouzari, a case that we described in our last appearance. In other words, this UN committee was indicating that Canada should not grant immunity in torture cases. The committee has reinforced with several other countries in recent years this position that all victims of torture must be provided access to justice according to the Torture Convention. The trend away from immunity in civil cases follows the elimination of immunity in most criminal cases concerning human rights atrocities, both internationally and in Canada. The statute of the International Criminal Court and the legislation in Canada and around the world that allows for war crimes trials in criminal courts explicitly prohibits anyone in any rank of government from claiming they have immunity. Ensuring that immunity does not bar access to justice in civil cases for the same acts is a natural extension. A second point in favor of Bill C-483 is that Canadian parliamentarians have already recognized the need to create exceptions to the State Immunity Act, with several exceptions already written into the Act and a new one under consideration. One of the exceptions in the State Immunity Act is for commercial activities. A second, the one that we have been discussing that was used by the Quebec Superior Court to give Stéphane Casamy the opportunity for a remedy, is for involvement in injuries and property damage that occurs inside Canada. In recent years, several proposed legislative amendments have also attempted to create an exception to the state immunity doctrine for terrorism, the most recent including Bill C-35, Bill S-7, and Bill C-408. In June 2009, then Minister of Public Safety Peter Van Loan introduced to Parliament Bill C-35, an act to deter terrorism and to amend the State Immunity Act. One of the primary goals of this bill was to create a new exception to Canada's state immunity law so that it cannot prevent lawsuits in Canada against foreign governments for certain acts of terrorism. Bill S-7 is an identical bill introduced after the prorogation of Parliament. It was introduced in the Senate in April 2010 by Senator Marjorie Le Breton and was recently passed by the Senate and has had first reading in the House of Commons. This bill will allow lawsuits for alleged acts of terrorism that occurred on or after January 1st, 1985, the year of the Air India bombing in which 280 Canadians died. Again, Bill C-483 is a natural extension. If foreign governments can be sued for commercial activities and for injuries and death they cause inside Canada, why would we not permit them to be sued for the torture and murder of Canadians outside Canada? If a new exception for terrorism proceeds, it should go hand in hand with an exception for torture and other violations of international law of this magnitude. A third point in favor of the bill is its strong potential for the deterrence of torture, war crimes, and other atrocities. Throughout history, these horrendous crimes have been committed with no accountability. But that has begun to change in recent years with the creation of the International Criminal Court and both criminal and civil cases being launched around the world. If governments and their officials know they will face justice in a court of law, they will be less likely to commit abuses. Not all of these international crimes will be completely prevented, in the same way that our domestic laws do not prevent all crimes. By the same token, one can only imagine how much more crime there would be if there were no police or judges to enforce domestic law. The same logic applies at the international level. If there is even the smallest possibility that increasing international enforcement measures could help prevent a future Darfur, Congo, or Burma, we must do all we can to provide justice. Finally, it is important to note that Bill C-483 would remove immunity and thus allow civil claims for 4 types of acts that have already been criminalized in Canada. The bill would remove immunity in cases alleging acts of torture, genocide, crimes against humanity, and war crimes. Parliament has already criminalized these 4 human rights violations in the Criminal Code and the Crimes Against Humanity and War Crimes Act passed in 2000 when it ratified the International Criminal Court Treaty. By amending the State Immunity Act, Bill C-483 would merely permit survivors to seek compensation and redress from the states that commit these criminal acts. Those are some of the key points that can be raised to make a compelling case for the passage of Bill C-483. C-483 was also carefully crafted to address potential challenges, and I will briefly review 2 key points in this regard as well. First, it is possible that someone will ask whether the amendment will throw open the metaphorical floodgates and swamp Canadian courts with lawsuits about human rights abuses that occurred overseas. The answer is no. The number of lawsuits will be limited. As with all civil cases in Canada, judges will have to be assured that a lawsuit has a connection to Canada and the province in which the case is brought. Even if a connection exists with a Canadian province, a lawsuit will only proceed if Canada is the best forum. If another country is in a better position to hear a case, perhaps due to the location of witnesses and evidence, and if that country protects due process rights, a Canadian court can dismiss the lawsuit. As a result, Canadian courts will only take on those cases in which Canada is both the best forum and the last resort. The language of Bill C-483 explicitly confirms that lawsuits for torture and other serious international crimes will only be permitted once all remedies have been invoked and exhausted in the country where the abuses happened. Any civil litigation lawyer in Canada will advise a potential client about these limitations. The number of lawsuits will also be limited by the fact that the evidence necessary to bring this kind of lawsuit is often challenging to gather because of the obvious lack of cooperation by authorities in the affected country. It is also difficult to find witnesses and ensure their protection. The psychological trauma suffered by most torture survivors is an additional barrier, and many people lack the necessary financial resources. The number of cases to proceed in other countries in which civil litigation for torture and other atrocities is permitted has been limited, likely due to a combination of these factors. At the same time, many survivors with whom we work talk about the importance of knowing that Canadian courts are open to these kind of claims, even if they themselves will not be proceeding with a lawsuit. A second potential critique of attempts to amend the State Immunity Act is a perceived impact on Canada's diplomatic and trade relations if Parliament signals its willingness to take foreign governments and individual officials to court. In response, one can point out, as I have described, that most countries of the world do not have legislation comparable to the State Immunity Act to provide protection from litigation, and that when the issue has been litigated, some courts have refused to apply immunity to civil claims for the most grievous violations of human rights. Clearly, these countries do not view their commercial and diplomatic interests as being at risk because of the possibility that someone in their country might sue Iran or other human rights abusers. The U.S. and Italian models show that although some countries have protested lawsuits targeting them or their officials, there is little evidence that lawsuits have led to major diplomatic retaliation. In addition, there should not be an explosion of cases against Canadian allies that provide proper redress through their own courts. As I mentioned, Canadian courts can dismiss those cases. With countries that are not close allies and do not respect the rights of their citizens, civil lawsuits provide another effective tool to convince them to change their ways. If the goal of deterring future abuses is in fact achieved by these cases as discussed earlier, the United Nations and foreign affairs departments around the world will have fewer situations of human rights violations raising sticky diplomatic issues. You may also wish to point out to colleagues that with the State Immunity Act as it currently reads, a very embarrassing and frankly outrageous situation arises for the Government of Canada. This committee heard Stéphane Kazemi, a Canadian, describe how the torture and death of his Canadian mother has resulted in so many years of pain and suffering in the prime of his life. In the same year, he was in court to seek some measure of justice at great emotional cost, and with CCIJ and Amnesty International as Canadian charities using scarce resources to support him. And there was the Canadian government using Canadian taxpayers' money to stand on the opposite side of the courtroom to argue against Stéphane's right to proceed with his case for his mother's torture and murder because it needed to defend its law, the State Immunity Act. Now, great pains were taken to express that Canada was not condoning the human rights record of the government of Iran, but the practical result is that it does contribute to the commission of human rights abuses. There are people being raped, beaten, and killed in the same Iranian prison right now as we sit here. Rather than seeking dismissal of these worthy cases, Canada has the power and obligation to help bring these abuses to an end. We hope the image of what Bill C-483 means in terms of human lives is what will stay with you and we hope that you will act quickly across parties to ensure its prompt passage. We have background materials and copies of our statements to leave with you to help you do that. Thank you so much again for this opportunity to discuss this very important issue with you today.
Thank you to both of our witnesses. Given the time constraints involved, it's already 25:02. We're only going to have time to have 6-minute rounds, including question and answer. So please bear that in mind, and I'll have to be quite firm about this today because of the other matter we have to discuss and the time that's involved in switching over to in-camera. That being said, we'll start with Professor Kotler.
Thank you, Mr. Chairman. I want to begin by commending the witnesses not only for their witness testimony today, but for really being the inspiration for, in fact, myself as a parliamentarian moving Bill C-483 because of our own discussions and interactions in this regard. So I want to commend you for your continuing commitment with respect to this type of legislative initiative. As you put it, that there is a global trend away from immunity, and if I may cite from your testimony that most countries in the world do not have legislation providing immunity to foreign governments, and many will allow victims to file claims in conjunction with criminal prosecutions. My question is, because you made reference to the United States and to Italy and the UK, if you might elaborate for purposes of our work here, what can we learn from those cases? You did make reference to the fact that there has been no flooding of the no floodgates, the diplomatic issues that may have concerned people here. Are there any particular legal issues that arose in those cases, or in the manner in which they were handled, or the recent judgment in the Supreme Court in the United States that can assist us in making the case for such legislation here in Canada?
Certainly. The key, obviously there are many legal issues in these types of cases. The key barrier really in all of them is immunity, and that is something that C-483 would immediately remove, and then we could move on to the other legal issues. That being said, I'll take, for example, the U.S. Supreme Court case. That's a situation where the court was able to look at the long history of civil litigation in the United States against human rights abusers, and to feel comfortable that in making its pronouncement that there is no immunity under their Foreign Sovereign Immunities Act, and see that there has not been disruption to diplomatic relationships. There has not been a flood of lawsuits. In the United States, there are a couple of decades of these types of cases which have been very important to survivors of torture and other atrocities, but they have been limited in number and in scope. The United States Supreme Court was able to look at that issue and say that there is no justification for having immunity attached under their statute. In Italy, there's, I think, an even more important point being made, which is that these are the types of crimes that simply cannot incur immunity. And that is a point that we have been trying to make, and that I think is really critical, is that these are not sovereign acts. The idea behind immunity is to protect other governments from lawsuit for sovereign acts, and torture and war crimes and genocide simply are not acts that a sovereign is permitted to engage in. And so the Italian courts, I think, have taken a very big step in that regard to recognize that issue.
A second question, which will be brief. You mentioned also that in Canada in the year 2000, we criminalized, in effect, war crimes, crimes against humanity, and genocide. Yet we did not pass parallel, civil remedial legislation. My question to you is, because governments tend to look to their departments of justice and foreign affairs for legal counsel as to whether to do or undertake an issue of this kind. Have you had any discussions with Justice or Foreign Affairs on these matters. And have you noticed an evolution in their thinking that maybe in the year 2000 they were not prepared to support something like this, but given all the developments that you've described in the last decade, internationally and in the courts of Canada as well, that they might now be more disposed to supporting this?
Unfortunately.
Okay, 90 seconds. I think that with the new war crimes legislation passed in 2000, of course, that was because Canada had ratified the new International Criminal Court Treaty and had that obligation to implement the treaty into Canadian law. So looked at the criminal cases and looked at our history in Canada of criminal lawsuits. And in that legislation, of course, followed the global trend in criminal cases, which is very clear that immunity is not permitted for anyone. I think the fact that civil litigation didn't come at the same time was not necessarily a reflection that at the time there wasn't interest, but simply that one was on the basis of an international treaty that had been ratified and needed to be implemented. When we have raised these issues with the Department of Foreign Affairs, certainly there has been an openness to the discussion. We had one meeting where there were some questions, the kinds of questions that we've discussed with this committee. I do think that the key concern is about the potential impact on foreign affairs, on diplomatic relations and trade. I think we have very clear answers to that as we've set out, and so we just really need to follow up on that. And certainly if you will be looking to them for advice, then we will be providing the same kinds of material. But I think the point has been very well made that in this period of time, things have progressed a lot in terms of the status of international law on immunity in civil cases, and certainly we might see some movement and some more willingness to support this as a result.
Madame Deschamps, vous avez la parole.
Well, right at the beginning, let me tell you that our party will be supporting Mr. Cotler's bill, and as you have just explained, Mrs. Stoyles, in 2005, my colleague Francine Lalonde had asked the government to amend the State Immunity Act to enable victims of torture in foreign countries to seek damages. If my memory serves me correctly, I should think that in 2005, the Committee of the UN Against Torture had already blamed Canada for inaction in legislation to help the victims of torture. I would like to, if you will allow me, to go back to the case of Mrs. Kazemi, where Mr. Hashimi, her son, pleads the argument that the case is constitutional, and given Canada's international agreements against torture, should oblige it to claim immunity. Mr. Justice Robert Mongeon of the Superior Court, who's hearing the case, will have to decide whether or not the present law infringes upon the Charter of Rights and Freedoms, if this should be the case. As a follow-up to all this, what would this all mean for you?
Is whether the State Immunity Act as it currently stands is constitutional or not, and complies with international standards. And as you said, the UN Committee Against Torture in a previous case, in the Buzari case, was responding to the decision of the Ontario Court of Appeal in the Buzari case when it said that Canada was in violation of its obligations under the Torture Convention by not providing compensation to all victims. That is, again, the issue in the Kazemi case, with a slightly different set of circumstances because, of course, she was Canadian at the time of her abuse. This is the issue that's still under appeal. So as we've set out, Stéphane himself has been given a right to proceed, but Zara Kazemi's own abuse has not been considered at the moment to give rise to a right as a result of the State Immunity Act, because the court refused to read in this exception for torture. All of this will be appealed, and so this is not yet at the end. In terms of what it means for us, this would really allow us to give a number of the clients who come forward to us some hope of seeking redress. It's not a huge number of cases. Many of the cases that, in terms of sort of the numbers that it would result in, we have a few clients for whom this would provide a right to a remedy. In most circumstances, the availability of witnesses, the emotional trauma, the lack of financial resources, and other factors create a barrier to proceeding. At the same time, the clients who come forward who have experienced this kind of abuse or who are from a country like Iran where there is this ongoing and significant level of human rights abuses really just want to see that there is a possibility of justice, that Canadian courts are standing up for their rights, and that some cases are allowed to proceed in Canada. So I think this would provide a measure of hope to a broad base of survivors in Canada. There are at least 1 million people in Canada affected by these issues, and it would send a very important signal about Canada's role in standing up for international human rights and not for torturers.
No, if the gentleman beside you, Mr. Eisenstadt, wanted to add something?
Has phrased the issue quite well in terms of the hope that these cases could provide to even those people who themselves will not actually bring lawsuits. As we're saying, the number of cases that will move forward based on the experience of other countries will be relatively small, but the impact for other survivors and the impact on the actions of other countries would be quite important. And I wanted to add, as you were saying about the Committee Against Torture's response to Canada's situation, the committee also reinforced that same issue, the obligation to provide remedies and access to courts to all survivors of torture. They reinforced that with several other countries after the case involving Canada. So that is not a one-time conclusion. They have reinforced that on a number of occasions.
Vous avez encore 45 secondes.
I think you have about 45 seconds left, ma'am. To preclude any confusion in this legal and constitutional aspect of the issue, could this enable, for example, citizens of other countries to sue Canada from their country of origin?
Against the Canadian government are governed by an entirely different set of rules. This law is really looking outside of the country, and the amendment that we're talking about here would apply to foreign governments.
Okay.
Mr. Marsden, please.
Well, thank you for the presentation. It's good to see you here again. I'm very impressed with the work that this organization does, along with Amnesty, and the battle that you've undertaken here. The fact that we even consider that a sovereign nation has a sovereign right to torture, that can even be discussed is in itself very disgusting. We do have a problem. C7 is awaiting debate in the House. C35 died of prorogation. C483 is teetering because of a potential election. But I want to say on behalf of my party that should there be an election and should the good people of Hamilton East Stony Creek send me back here, I'm going to be working with, I presume, the members of this committee to make sure that 483 comes forward again. But I think what we need to do as well is have a discussion about making it as comprehensive as we possibly can to include those positives that get lost along the wayside because of the proceedings of a minority parliament. It's very, very important. So I want to give you that commitment here today. And I just look down the aisle here and I see my friends nodding. The other thing that we have to address as members of Parliament is the order of precedent that this comes forward. Because if you're private members, and I happen to be, I think, 163, there's a long wait before you have. So we have to ensure that a bill of this importance gets a priority. And I commit also to work with my House Leader to try to get unanimous consent to get this up sooner, no matter who has the precedent on it. Considering places like Iran or Libya or maybe the Democratic Republic of Congo, I have trouble saying Democratic Republic of Congo, but anyway, if you've got Canadians working there, and let's just say that we made these changes in law here, has any consideration been given to the risk factor for Canadians abroad following this, what kind of reaction there might be? And that's something that concerns me. I might like a response, if you would, please.
Well, let me just first of all say thank you so much for those expressions of support. We know there's a lot of election talk right now, and that people are likely starting to have an eye to that potential, but we felt it was really important to have the opportunity to come. We know this committee has heard about this issue before, and that you have looked at and provided some statements in support of Bill C-483. We hope that we don't lose momentum for longer than that potential election period, and that if you are all back in your seats afterwards, that you will work with us still across parties to champion this. And that was really our hope today, was to bring it to you knowing that you have provided some endorsement of the bill, to really ask you to think about working actively on this and championing it and making it a precedent, a priority, as you've said. So I appreciate that very much. In terms of retaliation against Canadians abroad, I think the most important point to remember is that we are talking here about removing immunity for torture, war crimes, crimes against humanity, and genocide. So if another country were to look at what Canada did and say, well, you've carved out this exception to your State Immunity Act for those issues, we are going to do the same, we're still talking about Canadians implicated in those most serious crimes of international concern. And of course, Canada would have an obligation itself then to investigate those allegations and to bring people to justice if there were serious allegations. That obligation exists already under, many other
Well, my concern,
treaties.
though, is if you take a state like Iran, and right now following their elections and the leadership of the uprising, as they would call it, they're using the drug laws to destroy those young people now. They're hanging one every 8 hours. So the language of who's doing what in our courts is wonderful and truly important, but on the ground, there's a huge risk factor when you're dealing with people such as these who are prepared to do anything and everything. I mean, Libya today is an example when you watch the airplanes on television bombing their own citizens and strafing their own citizens. You realize you're dealing with leadership, or I don't even want to call him a leader, but people in control of a country that will destroy their own citizenry. So again, these are the kinds of major players that are around the world that cause that kind of concern. And your own point was getting rid of the victims so that there's no evidence. Right. And so those are very concerning. But I still agree with you that we have to bring this and continue, because the momentum has started. It's already there. I mean, this country was reluctant to sign on to the torture ourselves. It took us some embarrassingly long time to do that. So, but that momentum is there, and I agree we have to do it. And I have no further questions, Mr. Chair.
Thank you very much, Mr. Marsden. I think we're going to Mr. Hebert next.
Thank you. Thank you for a very, very thorough presentation. I took lots of notes here, and I honestly don't have a lot of questions because you've done a good job of answering most of them. I guess the one question that I could ask would be, what would be the arguments against the changes that are proposed in C-483? I know that the sense that I'm getting is that there's support around the table, and perhaps more broader than that. But what could somebody say against the idea of extending the State Immunity Act to these officials who have permitted or instructed for these atrocities to occur?
Yep, summarize again.
Not to simply repeat myself, but I do think that the 2 points that I made toward the end of my presentation are really the two that we have noticed would be the most discussed, I think. The first one being whether there would be opening of the floodgates to result in a lot of cases, and I really think experience shows that is simply not going to happen. The other, as Mr. Kotler also brought up, was the issue of diplomatic and trade relations and the impacts that might be there. and I really think that, again, the experience of countries like Italy, like the United States, shows that that's not a likely possibility. There may be complaints about an individual case here and there, but there have not been major repercussions from these types of cases. In addition, as I mentioned, if we're worried about our allies being dragged into court here in Canada, there are many tools at the disposal of courts that they certainly are not shy about using if they think that there is a case that should be sent somewhere else or would be in a better form in another country. They are very well equipped to deal with that. I don't know if you had a more specific question on that, or if that answers your question.
Well, I caught those two points that you made at the end of your presentation. I was just wondering if there was anything in addition to those arguments, and you're basically telling me that there is no other reasonable reason to oppose the amendments.
Can I just add the point, I guess, as Mr. Marston raised, I think there is sometimes this concern and this, the concern about what will happen to Canadians elsewhere, and what about what is already happening in Iran and Libya and so on. And I think the response is almost the flip side of the way it was presented, that right now we are seeing the commission of these abuses, right? All of that, exactly what Zara Kazemi faced in Evin prison, has gone on many times since. What's happening in Libya and elsewhere with the kinds of indiscriminate and widespread human rights abuses we're seeing, that is happening. And so what we really have the potential to do here is to send a strong message that this is not going to be tolerated anymore. Just as this is all very new, it's really only the last 10 or 15 years at the criminal level internationally that we've started to have institutions to enforce these laws. And we've got the ICC, and we've got some national level criminal cases for these issues. The idea of civil cases provides another opportunity, particularly when criminal cases don't always have the necessary resources because they're government funded. Civil cases give yet another mechanism to try to bring people to court, provide some measure of accountability, and send that clear message. And so I think that's really the most important response, that we have an opportunity to, in fact, save money in our budgets by not having to respond too little and too late to international atrocities, and we do have the possibility to save lives through this kind of deterrence.
Before I pass the balance of my time to my colleague, Mr. Sweet, I had one other brief question. Do you think there would be any difficulty with enforcement of these civil lawsuits if they were successful?
Certainly in enforcement and collection is always a challenge. There's no doubt about that. That being said, there are a few different aspects to these cases that are important, even if that isn't a possibility. Certainly a deterrent effect is given simply by a country or an official having to go into court and be confronted with the allegations against it. Certainly there's even further deterrence if damages can be collected and countries can be, say, hit in the pocketbook. In terms of looking at the importance of this, though, for the survivors of these abuses, I have worked with many survivors who say to me even if they somehow didn't win in court, just the ability to get to court and have their story told is a critical victory and a critical step forward in their own rehabilitation. And so the chance to get to court and have a story told and have a fair court in a country like Canada pronounce judgment about what happened is the most important thing, I would say. And then beyond that, the enforcement of a judgment, certainly you can look at any other countries around the world where these countries might have assets, and certainly most countries have assets in places like Canada, the United States, Western Europe. So enforcement would be possible, I would say, even if you might not be able to do it in the actual country itself. There should still be other assets and other ways to enforce that judgment and get some compensation for the survivors.
Unfortunately, that used up the time. We just hit 6 minutes exactly there, so that used up the time that was available for the Conservative Party. So Mr. Sweet won't be able to ask any questions. I want to thank our witnesses for coming in today. You've been very, very thorough. We are grateful to you for attending, and we give you our thanks. I'm going to suspend momentarily while we go in camera. And that means, unfortunately, that everybody who's not a member of the committee, +1 staff for each, has to leave the room. Thanks.